I'm Shreyash, and today I'm going to discuss a legal reasoning practice sheet with you. Let's begin with the passage. The passage starts with an occupier of premises or other structures like cars, ships, aeroplanes, or lifts owes an obligation to the persons who enter those premises or structures in respect of their personal safety and the safety of their property there. Until 1957, the rules which governed the obligations of an occupier were extremely complicated, but the same has now been considerably simplified in England by the passing of Occupiers Liability Act 1957. The nature of an occupier's obligations varies according to the kind of persons who frequent those premises, and therefore the occupier's obligations will be considered under the following three heads. तो पैसेज पढ़ते ही समय आपको अराउंड 2-3 लाइन्स और फर्स्ट पैरा में ये समझ जाना चाहिए कि पैसेज किस बारे में बात कर रहा है. तो दिस पैसेज इज टॉकिंग अबाउट द लाइबिलिटी ऑफ एन ऑक्यूपायर ऑफ सम प्रीमाइसेस. तो दिस पैसेज इज सेइंग दैट द ऑक्यूपायर्स ऑब्लिगेशंस विल बी कंसिडर्ड अंडर थ्री हेड्स: obligations towards lawful visitors, obligations towards trespassers, and obligations towards children. When the occupier of premises and the visitor have a common interest, or the occupier has an interest in the visit of the visitor is known as an invitee. When the occupier has no such interest, the visitor is known as a licensee. यानी अगर आपने एक premises को ऑक्यूपाई किया है और आपने किसी को बुलाया जिसके आने में आपका इंटरेस्ट है, तो ही इज़ एन इन्वाइटी. और अगर कोई और आ गया जो कि लॉफुली आ रहा है पर आपका उसके आने में कोई इंटरेस्ट नहीं है, देन ही इज अ लाइसेंसी. तो टू थिंग्स, इन्वाइटी एंड लाइसेंसी. नाउ both of them are lawful visitors. Yes, an occupier is supposed to take reasonable care to prevent any damage to an invitee from an unusual danger on his premises, which he knows or ought to have known. Therefore, the liability is towards the loss caused by an unusual danger, not only in respect of which the occupier was actually aware, but also of such danger which he ought to have known, जो उसको पता होना चाहिए था by default. So what is this second part of this para talking about? The second part of this para is talking about the liability of an occupier towards an invitee. Moving on, in case of a licensee, an occupier has a duty to give due warning of any latent defect or concealed danger in the premises of which he was aware. There is no liability for the loss caused by dangers not known to him. An occupier is also not liable for any danger which is obvious, and the licensee should appreciate the same on their own. तो ये जो पैरा है ये बात कर रहा है लाइसेंसी के बारे में, और इसका पिछला पैरा बात कर रहा था इनवाइटी के बारे में. Now, in case of children, however, an occupier must be more prepared. What is an obvious danger for adult may be a trap for the children. Moreover, children may be allured by certain dangerous objects which the adults may like to avoid. An occupier must guard the child visitors even against such dangers from which the adults don't need any protection. Let's look at the questions now. The first question is, Hassan is a gas fitter working with a gas agency. He was called by Douglas for fixing certain gas fittings in his house. While he was in Douglas's kitchen fixing the fittings, he went to the adjoining balcony to check the gas pipes. When he tried leaning against the railing of the balcony, which seemed to be covered by a piece of cloth, he fell through. Douglas's house was on the first floor of an apartment building. Hassan broke his leg as a result of the fall. Can Douglas be held liable for the injury? So here we can clearly see that since Hassan is a gas fitter and he has been called by Douglas to his house for fixing certain gas fittings, then what is Hassan? Hassan is an invitee. Why? Because Douglas is interested in Hassan's visit, right? So we have to relate these facts with this para, invitee. Let's look at the options. No, Hassan wasn't authorized to step outside the kitchen. No, as Hassan was a mere licensee and not an invitee. Yes, as Douglas owes a duty of care to anyone who visits his premises. Or yes, as Douglas had an interest in Hassan's visit to his premises. ये पैरा कह रहा है कि there has a common interest, or the occupier has an interest in the visit of the visitor. Either occupier, who is Douglas, had an interest in the visit of the visitor Hassan, which is fixing the gas pipes. So the answer should be D. Yes, Douglas had an interest in Hassan's visit to his premises. So Douglas is definitely liable for the injury. Let's look at question number 2. Abdul was relaxing on his balcony on the third floor of his apartment building. Suddenly, a portion of construction from the occupiers of the fourth floor collapsed and the sunshade and the parapet wall fell down on Abdul, resulting in his death. Can the occupiers of the fourth floor be said to have any duty towards Abdul? Now, this question is a free hit because, first of all, this whole passage is talking about an occupier's liability. यानी अगर आपने एक प्रेमाइसेस को ऑक्यूपाई कर रखा है और उस पर कोई विजिट करता है, वेदर इट बी एन इन्वाइटी, अ लाइसेंसी और चिल्ड्रन और अ ट्रेसपासर, आपकी लाइबिलिटी तभी होगी जब जिस प्रॉपर्टी को आपने ऑक्यूपाई कर रखा है उस पर कोई आए. सो इन दिस क्वेश्चन it cannot be said that Abdul, who has died due to the accident, was actually occupying those premises where the construction was going on. So this is important to remember. So let's look at the options. The first option says no, as Abdul should have exercised some caution by himself in the first place. The second option is yes, as they were required to observe a duty of care to anyone who might be impacted by their construction work. The third option is no, as they could not have anticipated Abdul relaxing on his balcony when the portion of construction fell. Or D, none of the above. I would say the answer is none of the above because the facts do not relate to the passage. Because Abdul, who had died due to the accident, was not actually in the premises. तो आप ऐसा कह सकते हैं कि yes, the construction workers are liable under, say, negligence or any other head, but not according to the passage. So all these three are only general observations. These do not relate to the passage. So the answer would be none of the above. Now question 3. Riya went to stay with her sister Sita in a building owned by Gary. Gary owned the entirety of the building and for all purposes the common staircase in the building. Owing to the wearing away of the cement, there was an evident depression in one of the steps of the staircase. Evident depression. Riya's heel was caught in such a depression because of which she fell and got injured. Can Gary be held liable for the injury caused to Riya? Now, जब भी आप कोई क्वेश्चन पढ़े आपको उसके फैक्ट्स क्लियर होने चाहिए. जैसे यहाँ पे ऑब्वियसली रिया हैज़ कम टू द बिल्डिंग ओन्ड बाय गैरी, विच मीन्स रिया इज आइदर एन इन्वाइटी और अ लाइसेंसी. सो in this case Gary is not at all interested in the visit of Riya in his building. So Riya is a licensee. Now let's look at the licensee part of this passage. The licensee part of this passage says, in the case of a licensee, an occupier has a duty to give due warning of any latent defect, यानी कोई ऐसा डिफेक्ट जो कि छुपा हुआ हो और डायरेक्टली नज़र ना आ रहा हो, और कंसील्ड डेंजर, छुपा हुआ डेंजर, इन द प्रेमाइसेस ऑफ विच ही वॉज अवेयर. यानी एक ऑक्यूपायर को अगर किसी ऑक्यूपायर के प्रॉपर्टी पे कोई लाइसेंसी आ रहा है तो उसकी ड्यूटी सिर्फ इतनी ही है कि उसे जिस कंसील्ड डेंजर या लेटेंट डिफेक्ट के बारे में मालूम है, ही इज़ अवेयर ऑफ दैट, उसको उस लाइसेंसी को वो कंसील्ड डेंजर कम्युनिकेट करना है. Furthermore, there is no liability for the loss caused by dangers not known to him. An occupier is also not liable for any danger which is obvious, and the licensee should appreciate the same on their own. So, इस case में we can say that the fact states that there is an evident depression in one of the steps of the staircase. So obviously, as we have just now seen, इस case में वो depression जो stairs पे था, that was really evident, and Riya should have, you know, looked at it on her own. So the correct answer would be C. No, Riya was a licensee. Gary could be made liable only for a concealed danger. Now let's look at question 4. Apurva, a 10-year-old girl, entered a public park which she used to go to every day in the evening to play with her friends of the colony. While she was on the swings, she spotted some attractive looking berries in a nearby shrub. However, the berries turned out to be poisonous, and Apurva had to be taken to the hospital where she was declared dead on arrival. Apurva's parents decided to seek compensation from the municipal corporation which managed the park. Will the corporation be held liable for paying the compensation? This is an important thing to remember, that in this case the visitor is a child. तो ऊपर चिल्ड्रन के बारे में डिस्कशन हुआ है. Let's take a look at it. In the case of children, an occupier must be more prepared. What is an obvious danger to a child, to an adult, is maybe a trap for the children. Moreover, children may be allured by certain dangerous objects. Okay? तो इस केस में क्या हुआ? The child saw some attractive looking berries which turned out to be poisonous. So it can be said that the municipal corporation had a duty, because it was first of all a child and the object was really dangerous. So there was some additional duty of care. So the answer should be B. Yes, being a child, there was a greater degree of protection that needed to be exercised. So according to the passage, the correct answer is B. The next question is, consider that in the factual situation described in the above question, there was a sign posted at the entrance of the gate which says, "Do not pluck any berry or fruit from the park." All the other facts remain the same. In such a situation, would the corporation be liable for paying the compensation? इस केस में भी you can definitely say that अगर कोई sign भी लगा है which says that do not eat the berries, do not pluck any berry or fruit from the park, तो it is definitely something what 10-year-old girl can definitely overlook. So इसका आंसर भी यही होगा, yes, as the instructions posted at the entrance gate was something that could have been easily avoided by a child. Okay, so that's all about an occupier's liability. I'll be back with the next practice sheet very soon. Thank you.